So Rob has done a tremendous amount of appellate work over the years. And what does that mean? It means that if you have a personal injury case as an example, and a defendant makes a motion to try to dismiss the case saying on an auto case, well, it's not a serious injury. And we've talked about on the show, folks, what by definition is a serious injury. By definition, in order to make a recovery from another party, not for your medical benefits, that gets paid whether you have a serious injury or not under your own policy of insurance. But from the other policy, you have to prove that the defendant, to recover pain and suffering, has caused an accident, that they're liable for it, and in addition to that, that you suffered a serious injury. Now, by definition, it's death, fracture, severe disfigurement, a loss of a fetus. Those are 4 clear categories. So if you came to our office and you had those categories or one of those categories, we could tell you that you're going to have the right to recover. The reality is that a lot of the cases don't go under those categories. The 2 major other ones are that you have a consequential limitation of a body system or part, and the other one says 90 out of the first 180 days you couldn't do most of your usual and customary things that you used to do. And so the importance of establishing those through the facts of each case can't be overstated. And what happens is we'll sit with the clients, we'll go over that in preparing for them. We'll talk about the things you could do before that you can't do now, things you're limited in doing. And what happens is at some point, defendants may, through their attorneys, try to make a motion to dismiss the case saying you didn't meet the serious injury threshold because it didn't fit one of those first 4 categories. And now what happens is someone like Rob may see that case. He'll see it in 2 places. One, when they make a motion to the lower court, sometimes, and he could address that motion where they're saying to the Supreme Court that the plaintiff hasn't proved their case of consequential limitation or 90 out of 180 days you're being unable to do your usual or customary things. And so now we have to oppose that. We oppose it by putting in evidence. We have to get affirmations from doctors. We have to show different facts. And sometimes we win those motions. Most of the time we do. And it's possible we don't. And they go to the appellate court. And then Rob would see it, and he would then have to argue, if the lower court found against us, he'd have to argue that the facts that were established through those depositions support that you were seriously injured, and the defendants would argue to the opposite. And what Rob was saying earlier, Rob, I think what you were saying on the show was that you really need to have those facts established. And if they're not established, the case could go down in flames, right?
Right, because at the appellate level, you can't be interjecting new facts into the case. The appellate division, which is our intermediate appellate court in New York State, they decide cases solely based upon the record as it existed before the lower court.
And, Rob, you've done cases for me even before you were my partner, many, many years on appellate stuff. And these cases literally turn on a fact. And sometimes it's frustrating because you know that a fact existed, but it wasn't presented and it didn't get out there. So that's our job, and that's why you got to get to an attorney quick.